Okay, welcome everybody back to the Road to Retirement. My name's Chris Anselmo, and I'm here with our co-host Tony Shore. And I guess it's not Minnesota in June, but it's actually cool here. It's in the 60s today. But how you
Oh,
doing?
wow. Well, good. I'm actually in Minnesota right now, and it's gonna hit. It's been in the 80s for days.
Yeah,
We haven't had any rain.
we
Uh,
finally got
every,
rain.
everything's drying up. Well, that's good because we haven't. I'll
We
tell you
had
that.
uh, we had 21 straight days of no rain, and that's like for us that's a drought. I mean, we usually get rain at least once a week, right? So probably
Right.
you too. Yeah,
It's the same. Yeah, it's the
yeah,
same here, especially this time of year. We're way down. Like, I mean, it's a drought here. All the lines are, or lawns, I should say, are dying, and they're telling us you can only water on odd and even days, and then only during certain hours. So,
yeah.
there's water conservation going on here, and there's a drought. So, and
Other than that,
we have air quality alerts, and it's gray outside, even though it's 80, no clouds, but it's completely gray because of the Canadian wildfires.
yeah, we had some of those days too here.
Well, it's been really bad the last couple of days here. And what they say is that to try to drive less and less emissions right now, because Minneapolis St. Paul area is a big metropolis. I
Right.
mean,
Yeah.
it's a big area, a lot of cars, a lot of
Yeah.
traffic, and the smoke and the debris in the air from the fires holds that in.
Yeah.
So the air quality isn't just the smoke, it's actually because of carbon monoxide and everything else is so it's bad. They say if you have any type of asthma or breathing issues, don't go outside.
Yeah. I
Yeah.
could see when I was driving in a certain road, one of the roads is a bit higher in the county than the rest, and you could see downtown, and it looks like a big hazy cloud over downtown. So,
Yep. Yep, that's what happens because of the wildfires and the ozone right now. It's crazy. So anyway, other than that, I'm great.
yeah,
Chris, how have you been?
I've been really good. So I'm
Good.
excited. My daughter's got a few things going on in her life right now. She's traveling abroad, and she'll be back, and then she's going back to. I think we told you before she was fortunate enough to get accepted to graduate school in Oxford, England. So she'll be going there later in the fall. But things are good. So I thought today we haven't talked about in a while. We have this like basic what we call peace of mind package. You know,
Yep.
what do you do just for your basic legal documents? You know, you have kids, you probably want to appoint guardians and things like that. I thought we'd go over that because a lot of our clients are beyond that stage, and we're using trust for them. But oftentimes, at least as a stopgap, we get these documents in place just so God forbid something happens in an emergency. Um, so I thought we'd go over that. I did a little outline of what these documents mean, so I'm going to try and put that up on the screen so
Good.
people can see that.
That's awesome. That is awesome.
So can you guys see that?
Yep.
Okay.
Last will and testament.
Okay. So the last will and testament is basically what happens when you're gone, right? What happens when you pass away. It doesn't do anything for you while you're alive. So even though you may have picked people to be your executors and who's getting what and all that, doesn't kick in until you're gone. So first thing we normally do in the last will and testament is we define who's your family. Like I'm married or I'm not married, I have children, don't have children, that type of stuff we put usually right in the front of the document. So when someone's reading it, when we're talking about who's your heirs and things like that, we know who they are. Second thing you normally do is choose an executor. So the executor basically is you when you're no longer here. So that person's going to step into your shoes, do what they need to do their banking, close out accounts, all that kind of stuff, and um, and basically we get letters of authority from the probate court that says, look, this is the right person for everybody to deal with, and we generally choose more than one. Normally, we would say it's a spouse. So Tony, your spouse would be your executor. She'd be you'd be her executor. But we usually have backups. Most likely, it's either brothers or sisters or children. So God forbid you died in a common car accident, and we need someone to step up and take over. If you don't choose an executor, or if your executor is not available, then the court's going to appoint one, and oftentimes it would be a local attorney because the judge knows they have jurisdiction over that attorney, and we've been appointed several times. Just like they know we know how to do it, so they appoint someone that they can trust to get it done.
Sure.
The other
Yeah.
thing is if you have minor children, you're going to want to appoint guardians. So again, God forbid something happens to you
Mhm.
prematurely and you have minor children, somebody has to be their guardian. So
And you have to think about those two things, the executor, who you're going to choose to be your executor, and who you would choose to be the guardians of your minor children if you have minor children, because those aren't easy jobs. People say, those aren't jobs that
yeah,
people necessarily want.
yeah,
So you have to think carefully. And it's a big burden to put on someone, even just the executor. So that's why I have you listed, Chris, in both of
uh,
those areas for me.
that's fine. I'll take all your kids. I don't think you have any minor children left, but
I
at
don't.
least that your wife doesn't know about. But so
No, no.
now the guardians, you got to think that oftentimes people pick their parents, but your parents might be getting up there in age, and
Oh yeah.
I don't think my mother, who's in her 80s now, would. Probably, mom probably didn't want me to tell people that, but anyhow, she probably wouldn't be
Of-
the best person to watch minor children. It's just
right.
it's cumbersome, and executors. The other thing you may want to think about is having a local executor, because
Yeah. Yeah.
if we have someone from out of like if Tony, if you picked me and it was an out of state executor, most likely I would have to put up a bond with the probate court because the probate court doesn't have jurisdiction over that person in another state, and
Yeah.
they're afraid that they may abscond with the money, so they would. And bonds are pretty expensive.
Yeah.
So once you got those two things done, then we go into okay, who's getting what. So something called specific bequests are specific items. I want my Rolex to go to my son. I want the mom's earrings to go to my daughter. So anything that's specific, $10,000 to go to Tony Shore. He probably wants 100 grand, but that's okay. $10,000. So anything that's specific, we list out.
Right.
Now we don't want to get, I won't say petty, but like you don't need to say who gets your dish towels, right? I mean,
Yeah.
if it's something of either of family value, you have an heirloom or something,
Sentimental value.
yeah, or something that's really valuable, you might want to do it specifically.
Diamond ring or something that's been
Yeah,
in the family a long time, an antique,
right,
those types of things, but not, you don't want to get, yeah,
right, right.
crazy.
And generally, if those items are not there, then they're just not there, right? So if you tell me you're going to get my Honda Ridgeline, and I don't have a Honda Ridgeline at the time, then you just don't get it, right?
Right.
So residuary bequest would be everything else. Then, so once we took care of the specific bequest, generally it says, look, give everything else to my spouse. If my spouse isn't alive, give everything to my kids. God forbid they're not alive, give it to the grandkids, right? Or again, they don't have to be family. You can put down whoever you want. You can put down some people put down charities or churches or favorite charities. Anybody you want, friends, family, could be listed in the will. Also, oftentimes people disinherit people,
Hmm.
right?
Ouch.
So if you have a someone who's legally your next of kin, say you have an estranged child, and you don't want to leave them anything, so you would specifically mention it. I'm not leaving anything to XYZ Tony Shore's long lost kid, right? So we do that so that we don't. It used to be say, like, let's give him $1. So that, and the reason was, look, we didn't forget about him. So if we didn't mention him at all, people might say, well, you must have forgot about him, so he should get a share. We don't do that anymore because legally we have to find him and give him $1, right? So if they're
Right.
estranged, you don't know where they're at. I don't want to keep this probate court, this case open until we can find them. So usually we just say, look, we're not giving them anything. Now, so what really happens? So the person dies. We have to probate the will. We've heard horror stories about probate. It's good and bad, but it's not all awful. And sometimes probate's less expensive than doing other things. But anyhow, the first thing happens, we file an application, say, look, we're going to submit the will. These are the kids. This is the spouse, and this is who we listed as executor. So the executor gets appointed. I probably should have a little slide in there, but the executor gets appointed. So now once the executor gets appointed, so Tony, let's say you're my executor.
Hmm.
So now it's like you're me, right? So you go to the you go to the banks, you go to the wherever I have money, close all those accounts down. So basically, you step in the shoes of the decedent, and you get a little slip of paper from the probate court. Here it's called letters of authority, so that you can say, "Look, probate court says I'm the executor. Here's my little seal of approval." So then the banks know you're the right person to deal with. So you can't just walk into the bank and say, "Look, the will says I'm the executor, and he died. Here's his death certificate. Let me go do what I want," because the institution isn't going to take the risk that that was his last will,
Sure.
right? So he might have made one out 3 days before he died, and that one's 3 years old. So they're not taking that risk. They said go down to the probate court, get your little permission slip, letters of approval, and then come back. Okay. So once you do that, then we have to file what's called inventory. Like, what are all his assets? He's got a house, he's got bank accounts, he's got some brokerage accounts. So anything that's stuck into the decedent's name, we have to list as an inventory. Then we would pay creditors. If creditors make a claim here in Ohio, they only have 6 months from the date of death to make a claim. If they're late, they're out. Right. So we had a case 6 months and 1 day, and the judge says 6 months and 1 day is not 6 months. So creditors out. Um, so and pay any timely creditors. Eventually, they'll file tax returns. You got to file the final 1040, possibly a tax return for the estate. And once all that's done, and you satisfied all that, then there's a final accounting says, okay, we took in $100,000, we paid out $23,427 for all these expenses. This is what's left, and then this is what's going to go to the beneficiaries. So once the final accounting gets set, then we could pay out to the beneficiaries. So that's basically the whole process. It's a little more complicated than that, but
Sure.
for our time, that's pretty good enough. So the next document we normally do is the durable financial power of attorney. So the durable financial power of attorney is appointing someone while you're alive to handle your financial affairs for you. So we would choose an agent. In a power of attorney, there's a Tony, you would be called an agent. So there's principal and agent. So I'm the principal, you're the agent. And we can list them in order of preference. So if we have two or three people listed, oftentimes it's a spouse and it's a child and it's Tony Short. Now, the order of how they do that is, at least in our power of attorney, we lay out, we give them choices. Do them in the order named, right? So spouse first, the spouse not available, the son, if he's not available, Tony Short. Okay. So we could do it in the order named, or sometimes the client says, "Look, I don't care which one of the three kids do it. Just let them all do it." Right. So we could check a box and say, "Look, they can all act independently," or we could check a box that says they all have to agree. So you can choose your agents there, and you want to make it simple because you don't want the banks to reject the power of attorney because they don't want to deal with. Look, I got to make sure all three of them agree. Right. So oftentimes we say it's better if one of them does it than two or three. So basically, this document is to handle all property, finances, and legal affairs of the principal. Now, it could be so durability means it used to, and still the case. So, Tony, if I gave you a power of attorney and I didn't make it what's called durable, that would mean your powers are only as good as my powers. So if I became disabled, you're now disabled. So people are like, well, that's not what we want. So they created this concept in law says durability. So the durability means that this power of attorney survives my incapacity. So if I become incapacitated,
So this is like a living power of attorney. So this is
right,
like I have a power of attorney for both my parents. I have power of attorney.
right,
So that's for when they're living if they're
right,
incapacitated.
right. So, but if it's not written in a fashion that makes it durable. If they became incapacitated, you can't. Their power of attorney would end because you're just as good as them, right? So you would be incapacitated. So most of them, if they're drafted property, are what we call durable. So it
Well,
does
I'm gonna
survive.
double check
Yeah.
that.
So it does
I better
survive.
double check
It
that.
does survive incapacity, and that's what we really want, right? If mom and dad become incapacitated, I want to be step up and handle their
Right.
financial.
That's the whole reason we
Yeah,
have the power of attorney.
yeah. And
Yeah.
the next thing on there is immediate or springing. So immediate means if I don't mention it, otherwise it's going to be immediate. So if I give you a power of attorney and I'm silent on that issue, your power of attorney is effective today. So you would be able to go do my banking, do whatever. Basically, you're stepping in my shoes today. And a lot of people say, I don't want that. I want it to be, Tony, you don't have this power until I become disabled. So that's what we call springing. So normally between spouses, we make it immediate. Like my wife could go sign my name, I could sign her name today.
Yeah.
But for everybody else, maybe springing. So springing says Tony Shore's powers will kick in if and when I become disabled. So there's standards in there. Doctors have to sign off, that type of thing. Okay, now your power of attorney is active because some of the concern is like this is a very dangerous document, and if you get it to someone you don't wholeheartedly trust, like Tony, if I like I wouldn't mind you. So I give you the power of attorney. You could go
Yeah.
clean me out today. Like you could now. Obviously, there's laws against. You're supposed to be acting on behalf of me, not taking the money and running. But there's a risk there that that
Sure.
you so
Sure.
so they're really intended to avoid guardianship. So if I don't have a power of attorney in place and I become disabled, somebody's going to have to go to the probate court to be appointed a guardian of the what's called the property. So and it could be two different people. So the guardian of the property is the one that takes care of all my property,
Hmm.
tangible or intangible, real estate, bank accounts, anything that's property. Okay. So, like anytime we go to court, it's going to be expensive, and if there's a way to avoid that, we want to do it. So, this power of attorney is what we use. Our power of attorney, you get them on the internet for 2, 3 pages. Our power of attorney is 23 pages long, and it covers, if the third moon of Mars is in line with the second moon of Venus, we got a clause for that, right? So you rather have a little more in there than too little because if you have too little in it, sometimes it doesn't work, and we could tell you stories about that. But so you want this in place. Now, the power of attorney ends when you end. So if I die, your power of attorney is done. Then the will kicks in. Okay. So even though you have power of attorney, once the person dies, that power of attorney is gone. Okay. So next one is healthcare power of attorney. So here in Ohio, at least we got this standardized because all of us attorneys were drafting our own for a while, and the doctors were like, "Look, we don't have time to read
It
these or
was a
send them.
mess. Yeah.
Yeah, we don't have time to read them or send them to our legal counsel. Look, we need to operate now, right?" So the healthcare power of attorney, the Bar Association, the Medical Association came up with some standardized forms, and maybe it's the same in Minnesota, but so the doctors say, okay, yeah, that's the form. Okay, we're good to go. So you're going to choose your agents. Now, oftentimes these are people different than the people you chose to handle your money. So maybe it's someone in your family that's in the medical profession, and you value their opinion more than you would value the guy who's driving a truck. Nothing wrong with driving a truck, but if you
Right.
have a doctor
Right.
in the family, I'd rather
Yeah.
him making medical decisions for me than
Sure. Yeah.
so
Makes
choose your
sense.
agents. So these is for all your medical decisions, and it's a little bit different than the financial power of attorney in that it's only effective if you can't make your own decisions. So I remember a time when my grandmother was, I think, 101 at the time, and my mom and my aunt were her medical power of attorney, and they were talking to us about what they should do, and the doctor said, "Slow down." She's like, "Why?" She said, "Because I'm going to ask grandma."
Yeah.
Right? So if you can't make your own medical decisions, either because let's say you're unconscious, you're in a car accident, you're unconscious, or you have
Dementia.
dementia, Alzheimer's, and
Yeah.
you're not legally capacitated to make that decision. And then the healthcare power of attorney steps up. Uh, and this is intended to avoid guardianship of the person. So there was guardianship of the property. There's also guardianship of the person. And again, it could be different people. Like I would, you have someone in your family that's a CPA and they're going to handle the money, and you have a nurse in the family is going to handle the person. So we really want to avoid these if we can, because again, going to court is always the most. It's not the least expensive way to do that, right? Because you got to pay the attorneys. Go downtown, right?
Sure.
Okay. Now the other legal document is the living will, which is different than the power of attorney. So the living will, and most of you have heard, it's called pull the plug, right? So pull the plug basically, so the living will says, look, doc, if I'm ever terminally ill, permanently unconscious, and I don't have any chance recovery, I don't want to be kept alive artificially. So if it's that grave of a situation, call the family in. This is my direction. Don't ask the healthcare power of attorney. I'm telling you, this is what I want. Okay.
Yeah.
Now, if you don't sign a living will, then the healthcare power of attorney would make that decision. Right. Also, in the living will, generally, I didn't put that in here, but there's also usually whether you want to be an organ donor, right, that type of thing. And there's one other document we have that I should put up there. It's called the HIPAA release. So the HIPAA release is so they can have access to your medical records.
Ah, yes.
Because
That can be important.
yeah, because it's strange enough that the healthcare power of attorney says, you can kill me. You could terminate my life, but I didn't give you permission to look into my file. Like,
Makes
so
no sense. Well, and
yeah,
I have a question for you though,
right,
Chris, because a lot of people I think get this confused, and I know uh, my wife and I over the years this has come up. A lot of people need to understand the difference between a living will and a will, and of course the simple thing, and people
yeah,
know a will
yeah,
is after you for when you
yeah.
die, and a living will is while you're living. But isn't the I noticed you had it up in the will, but when my wife and I, when people are younger, they make a living will, and in there they have choose guardians for minor
Yeah,
children.
that's still a last will and testament. So the
That's
living,
part of the. So
yeah,
that's not part
yeah.
of the living will.
No, the
That's a
living,
last will and
I
testament.
really wish they would change the name of it. The living will is just basically pull the plug. If I'm ever terminally ill,
Sure.
permanently unconscious, and like
So that's all it's for, really.
yeah,
The
so it
living will.
happened,
Okay. Okay.
it happens, and it can happen at any age. My ex brother in law, was sad case. He was at my niece's house putting on, and he had a company that did siding work and construction work. He was on the roof, and something happened. I don't know if he had a heart attack, a stroke, whatever. But he fell off the roof, landed on his head, and never woke up. And so, unfortunately, he was being kept alive for days by ventilators and machines. And they said, look, if we take him off these machines, this is the best he's getting, because the brain had separated from the stem, and he's not getting any better. So that's the pull the plug situation. So
Sure. Sure.
they don't. This isn't for a head cold, right? So I mean, normally you have a team of doctors or a committee of doctors that come in and consult with the family and say, look, this is it, right? He's not getting any better. So
Right.
so, but these are important documents to have in place, because if not, we got to go to the probate court to get somebody appointed to do all this. And again, that'll get time consuming and expensive.
Sure. Well, this is great information to have, and you've really clarified these areas, and really understanding these areas. I think a lot of people say, okay, I can figure this out now. But I don't think no one should do this on their own.
Yeah.
Obviously, this is why there's people like yourself who are estate planning attorneys and work on this. And you actually have the ability to tie it in with as a
Yeah.
tax professional,
Sure.
as an estate planner, and as a financial planner, which is a huge benefit. And so, how can our listeners get this peace of mind package and learn more about this or set up a complimentary consultation?
So there's a banner on the bottom there. If you can't see it, the phone number is 216-485-1040. And our law website is anselmolaw.com. So, Tony, just a little bit. Oftentimes, it's not that your document is, you grab something off the internet. It's not that it's wrong, but sometimes it's just not complete enough, right? So, we had a situation years ago where someone grabbed a durable power attorney off the internet, and we think we talked about this on the show. So, two sisters owned a house together, and the one sister became disabled and wasn't able to function. So the other sister wanted to sell the house and put her in an assisted care facility.
Sure, makes
But the
sense.
but the financial power attorney that they got didn't expressly give them her power to sell real estate. So so I said, well, you can try, but I don't think any attorney or title company is going to accept it because it doesn't say that your sister gave you authority to sell her half of the house. So the situation said, well, what should we do? And I said, well, I hate to tell you this, but um, you could either apply for a guardianship, but if you apply for a guardianship, her half of the money has to, when you sell the house, her half of the money has to stay for her. And if you do that, she's going to lose all her governmental benefits. So we didn't do that. So second scenario was, well, you can wait till she passes away. Eventually, she passed away, and then the sad part was that whoever did the deed didn't make a joint survivor, so they had to go to probate court to, you know, to so the
What a
person who's
mess.
yeah, what a mess. So the person who's alive got her half of the house. The person who passed away, you would think it would go to the other sister, but the person who passed away also had there was other three other brothers and sisters. So it became a mess. So, and it could have been, it wasn't that the power of attorney on its face looked bad, but it just wasn't complete enough, right? That's why ours is 22 pages long, right? So there's a lot in power of attorneys because you might need to do planning for nursing home planning,
Sure.
Medicaid planning, and if all that authority's not in there, they're not going to let you do it. Okay, so again, if you need help with this peace of mind package, call our office at 216-485-1040, or go to our website, anselmolaw.com, and we have a calendaring system on there that you can just set an appointment when it's convenient to you, or again, you can call our office.
Awesome. Well, Chris, great show. And I think people should pick up the phone, give you a call, make sure that they have it covered so they have peace of mind. And that
And, that,
does
and,
it.
that's why we call it peace of mind, right?
Yeah, exactly. Exactly. Well, thanks, Chris. Great show. And listeners, thanks for tuning in or viewing, whichever you're doing today. But that does it for today's episode of The Road to Retirement with our host, Chris Anselmo.
All right, see you next week.